Sure. All right.
All right, thank you. All right, everyone's here. Hi, everyone. Thank you for being here. Can everyone hear me okay out in Zoom land? Okay, great. So welcome everyone to, this is the public hearing, public forum for as part of our annual judicial retention process. My name is Angela Arsenault. I'm a representative from Williston, serving as chair for this biennium. The way we'll do this tonight, all of our witnesses are on Zoom so far. And we have 5 folks who have signed up. So I'll share with you the order that we're going to go in, and then I'll call you each up when it's your turn. But we'll start with Kyle Klaus, and then turn to Erica Marthage, Frederick Bragdon, Kelsey Schweitzer, and then Chris Roy. And I'm going to ask that you do your best, please, to keep your comments to about 5 to 7 minutes each. That would be wonderful. And we do need to swear you all in. So we'll do this all at the same time. Now, if you can all each raise, everyone who will be testifying, raise your right hand. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes,
I do.
Yes. All right. Thank you very much. I would like to just quickly have everyone here at the table introduce ourselves. I've already gotten a chance to do that, so I'll turn it over to Senator Palomar.
Senator Brian Palomar, I represent the Rutland District. Sorry.
Senator Martine LaRocque, represent Burlington, Winooski, Essex Junction, Essex Town, and Colchester.
Senator Terry Williams, representing Rutland County. Representative Tom Oliver, I Eldon, Wanton.
Hi, folks. Representative Connor Casey from Montpelier.
Great, and I know we'll have at least one other member joining us in a few minutes, but we would love to get started. So we will turn it over to Kyle Klaus. Please correct me, anyone, if I mispronounce your name.
Sure. So my last name is pronounced Klaus, like Santa.
Klaus, thank you.
I'll just read from my prepared remarks here, and I'll keep it within the time limit. Members of the Joint Committee, thank you very much for the opportunity to speak with you this evening. I regret that I cannot join you in person, which would have been my preference had I not moved last fall. My name is Kyle Klaus, and I would like to share my concerns about Judge David Barra's retention and respectfully ask the Joint Committee to recommend that he not be retained. I must note before I continue much further that the views expressed today are my own and not those of my current or former employers. I'm an attorney licensed to practice in the state of Vermont. My license number is 6764. I worked as a staff attorney for Legal Services Vermont from October 2023 until November 2025. I represented low-income Vermonters in eviction cases. My former colleagues at LSV and Vermont Legal Aid are easily the most brilliant, compassionate team of attorneys that I've ever had the pleasure of working with. I took enormous pride in our work. Shortly after Judge Barra cycled into Addison County, we observed his palpable antipathy to tenants. In my experience, Judge Barra has not treated these Vermonters with the respect and dignity they deserve. The experience of appearing before Judge Barra left at least one of my former clients with their confidence in our judiciary's capacity to vindicate their rights profoundly shaken. Before the agency's budget crunch last fall, LSV operated rent escrow clinics in 5 counties, including Addison. Several LSV attorneys would be present in the courthouse and available if an eligible tenant wanted limited representation for their rent escrow hearing. When both parties are present, rent escrow hearings are rarely, if ever, held at their scheduled time. Judges encourage the parties to continue talking, within reason, of course, in hope that they may stipulate either to a global resolution or to a rent escrow order. The clinics were an invaluable resource that could steer landlord and tenant toward a mutually beneficial outcome. And it was for this reason that Chief Justice Reiber and countless Superior Court judges, active and retired, were among the clinic's admirers. In contrast, it was far from assured that Judge Barrow would permit LSV attorneys adequate time to speak with their clients and discuss potential resolution. Before a rent escrow hearing in Addison County, one of my former colleagues who was appearing remotely tried to speak with her client, who had appeared in the courtroom and did not have a cell phone. This is quite typical with low-income clients. Court staff did not appear aware that the courthouse had a telephone and the tenant could use, so that my former colleague and her client were made to use the courtroom's teleconferencing capabilities instead. She was unable to have a complete, confidential conversation with her client because Judge Barrow returned to the bench and would not provide additional time to converse. During another rent escrow hearing in Addison County, my client testified at length about the downright appalling conditions in their home caused by the landlord's breach of the warranty of habitability. Notwithstanding, Judge Barrow ordered their rent paid into court for premises that were arguably condemnable. In a Bennington case, a different self-represented tenant filed a motion to continue their rent escrow hearing in the form of an unsigned letter, with the landlord's attorney copied. The tenant explained that she had medical appointments at Massachusetts General Hospital in Boston, scheduled months earlier and related to her ongoing and unavoidable health concerns. She explained that she was making the request in good faith and without any intent to delay the proceedings unnecessarily. Judge Barrett denied this tenant's request because her motion did not substantially conform with the court rules. Most concerningly, Judge Barrett departed from common procedure in rent escrow hearings and applied a novel interpretation of the rent escrow statute, 12 VSA, section 4853A, to preclude tenants from presenting evidence at the hearing if they did not file a memorandum of opposition in advance and request an evidentiary hearing therein. In my 2 years representing tenants in eviction cases, I never once encountered a client who was independently aware of the memorandum in opposition requirement, nor any judge who prevented them from presenting evidence in what is often the tenant's only court appearance before losing possession of their home. I have studied the rent escrow statute in exhaustive detail and wrote a forthcoming article for the Vermont Law Review on the dangers posed to tenants' constitutional rights by a conventional application. The danger posed by Judge Barrett's anomalous reading, which renders the hearing all but illusory and the tenant a mere stage prop, is even greater. When LSU made the painful decision to withdraw from Addison County due to its budget shortfall, my stomach sank at the prospect of self-represented tenants appearing before Judge Barrow without my former colleague's assistance or bearing witness. Returning to the Addison County case involving my former client in substandard housing, hearings on our repeated emergency motions for injunctive relief to restore the basic necessities of life, supported by affidavits, scores of photographs, were not treated with the urgency they warranted. In response to the third such motion in October 2024, in which my client swore that their family lacked heat as winter fast approached and feared the imminent structural failure of the home's floors due to unmitigated water damage, Judge Barrow waited 4 days before issuing an order that appeared to ignore our request for a temporary restraining order and set the matter for a hearing. At this hearing, days later, the landlord appeared to perjure himself during cross-examination. When I pressed the landlord further in order to bring the falsity of his testimony into starker relief, Judge Barrow abruptly continued the hearing to another day. I will never forget how I felt on that long drive back to Burlington from Middlebury, empty-handed, with no order restoring heat to my client's home. I imagine my client felt even worse that night as the temperatures dropped. As an officer of the court, I feel duty-bound to bring the foregoing concerns to the Joint Committee's attention so that the full promise of Article 4 of the Vermont Constitution may be realized. That every person ought to obtain right and justice freely and without being obliged to purchase it, completely and without denial, promptly and without delay, conformably to the laws. It is in this spirit that I respectfully urge this Joint Committee to recommend against Judge Barra's retention. Thank you very much for your time this evening.
Thank you, Attorney Kloss. And I should have mentioned at the beginning, folks may know this, but just in case you don't, this hearing is not an opportunity for us, members of this committee, to engage in a dialogue or a conversation with our witnesses. So really, we thank you for being here and for your time.
Thank you.
Is their testimony going to be submitted so we can read it? It was submitted.
I know, yes, this attorney.
So I have since, the remarks that I gave this evening are slightly different than what I sent the committee, and so I prefer to send them an updated draft.
Sure, that would be great.
Thank you.
Thank you.
Thank you.
You did mention additional materials in that original letter that you sent to us. If you have them or find them, please feel free to send them along.
I have found, yes, I will.
Thank you. All right, we will go next to Erica Marthage. Are you there, State's Attorney Marthage?
I am.
Hello.
Can you hear me?
You
Yeah.
can.
Hi. I just drove down from Montpelier.
Oh.
Just got home like 20 minutes ago. So I'm here. I wanted to speak on behalf of Judge Malone. I did not provide anything in writing. I've been listening to the retention hearings this week and just happened to hear the one involving Judge Malone last night and wanted to take the opportunity to give my perspective. I know many of you. I've been the Bennington County State's Attorney for almost 20 years. I've practiced in Vermont courts for more than 25 years, and I've been a state employee for 26 years. So I've been in front of a lot of judges. I have appeared in front of a lot of judges that have little to no courtroom experience. And I've just noticed a few things about Judge Malone that I wanted to share. First of all, I can say with absolute certainty that being a judge is, I can imagine, a very difficult position for many reasons, not the least of which is the training and mentoring that goes into new judges is virtually non-existent. The idea that a brand new judge would be I didn't know any of these things that I heard her say last night. So I had never met her. She's been in Bennington since September. And I was pretty shocked that you had an individual in front of you that was placed in a seat 3 hours from her home, but had no mentor from the beginning, no support, was in a building by herself. Again, I've been in practice in front of dozens of judges, and it's luckily in Bennington, we have family court and criminal court in the same building. And every new judge that has ever been placed in Bennington has relied heavily on the other more experienced judge that is also in the building. And that's been noted. They have been pretty open, both judges, with the fact that they confer pretty regularly about the workload and how to actually do the job. I understand the concern with the length of time it takes to get written orders, but I can just give you my observations of Judge Malone, which are that she is thoughtful. She's respectful to the parties. Juvenile court is a very challenging court to be in because it's not two people fighting over marital property or visitation or finances. It's attorneys for parents. There are, in many cases, no less than 4 attorneys in the room. The state's attorney, maybe an attorney general, assistant attorney general, maybe both parents get an attorney separately, even if they're an intact couple. The children have an attorney. There's a guardian. Typically, there are communication specialists. There are a lot of moving parts. I like to explain to folks that I'm hiring that I think juvenile court is one of the more complicated courts you'll ever appear in. And you're dealing really with very emotional, fundamental rights of right of people to parent their children and the right of children to have their basic needs met. And Judge Malone's done a great job in that area. She obviously is someone I heard her speak of her having a family, her kids or a child, and last night, and that definitely comes through that she has a really nice affect when she's speaking with kids. Typically very difficult teenagers respond to her questions, which is not always the case. She comes across as very personable. We've done a number of contested hearings. I don't have any idea what her trial experience was, but I can only imagine that if you don't have a lot of trial experience, it would be very daunting to go into a courtroom and have 4 attorneys making legal arguments, and you need to have the confidence and the knowledge to make rulings on those in the moment. And I have seen her rule, not always in my favor, but not off the mark. So it's very challenging, I think, to have a new judge have the confidence that is really needed to run a courtroom. And my experience has been that she's done a good job with that. I think when issues need to be addressed that are pressing for time, it may take her a while to get a written decision out, although I have not experienced that. She gets written decisions out in our cases about on the same timeline that any of the other judges get written decisions out. But she does make findings and ruling on the record for things that need to be taken care of right away. So, and again, we're dealing with the safety of children, the rights of parents. So those are things that she's deciding when she needs to. The written decisions that I have received have been clear to me why she's ruling a particular way. She maintains decorum in the courtroom, which I think is super important, because I can tell you that not all judges have been great with that, particularly lately, when you have litigants that are swearing and calling the judge names or the social workers names or being disrespectful. She maintains that decorum. And when you're talking about, I heard there's some discussion last night about judges need to be respected. There's nothing that undermines the respectability of a court more than when you have a litigant that's swearing at the judge and a judge that just listens to that. And I understand that people have bad days and those things happen, but everyone else in the courtroom is sitting there thinking, how is this happening? And Judge Malone has not let that pass. So I think that we need individual. It's a little disturbing to me that there was so much focus on things. I didn't get an invite to be here. I only happened to know that her hearing was coming up because I've been watching the hearings, because I hadn't appeared in front of her before this past September. So I wouldn't have gotten an invitation for her. And just hearing the steps that she's taken to address the concerns regarding her writing and the delay in getting orders out, I think is wildly appropriate. I think the problem that we run into are when we have individuals that get elevated to a judicial position and then think that they do not have to answer to anyone for the issues that or improvements that they may need to make. And that's clearly not what I got from hearing Judge Malone speak last night, and it's definitely not what I've experienced. She has been open and forthcoming with the other attorneys and myself about our practices and the way that we typically do business in Bennington, particularly in juvenile court. We have a huge docket, and I have yet to see any issues that would cause me concern for her as a judge. I think that she's new at it. I think I think it takes years. I think no one really knows what they've signed up for when they take the job. It sounds really great, but I think once you get the job, maybe you're not convinced. It's really hard. It's very difficult. And I think that it's important that we make room and provide mentoring and training and for individuals that have families and that have lives outside of court. We don't want judges that work 7 days a week. So
Thank
you.
Yeah, not trying to cut you off. You're at about almost 10 minutes, so I just want
no, I'm
to.
good.
Okay, great. Well, thank you for being here and sharing your thoughts.
Thank you.
Next we will move to Frederick Bragdon.
Hi, this is being recorded, right? I see affirmative head shake.
That's correct.
Oh, marvelous. So you can put this one in posterity because I'm about to agree with my arch rival in Bennington, as I'm one of the supervising attorneys in the public defender's office and have been there since '97. But Miss Marthage and I talked about making sure that we both showed up in support of retention of Judge Malone. And I have a very narrow area I want to talk about. So my experience with Judge Malone, who is new to the bench, and I don't have the benefit of listening to her talk last night, is in child in need of services petitions and in delinquency petitions. I don't do divorce as a public defender. I don't do support hearings as a public defender. But what I want to talk about is judicial temperament. And I think that this should be the first priority when judges are being selected, because temperament is not something you can teach. It's the personality they bring to the table, and they might be able to modify it a little bit, but they're not going to significantly change it. They are who they are. You can teach book law. You can teach time management skills. You can teach people how to use the computer, but you can't teach personality. I've seen Judge Malone be able to de-escalate swearing, rude parties who are upset, complicated with mental health issues, setting a line with them, but not going to the extreme, which I think a weak judge would do, which is threatening them or holding them in contempt. That just doesn't de-escalate the situation, just adds to the situation. I've seen her talk and invite every child to talk in front of her, encourage them to speak, but not sit there patiently drumming her fingers, waiting for beads of sweat to form on their foreheads when it's just difficult for them. One of the biggest fears I talk about with juries is getting on the stand, because it's talking in public. And I think that she's very respectful of that, of people other than the attorneys. We all do that because we like doing that. But for the parties who come before the court, especially people who are developmentally delayed or young or aren't doing well trying to meet the goals of succeeding in the court for whatever reasons that may be, so they're struggling with that. So that's what I want to say. So you can get some of your time back from Miss Marthage's 10 minutes at this point. And I would hope that you would all strongly consider retaining Judge Malone.
Can I just ask, just for the record, I don't believe he said his name on
Yeah,
the
I
record.
don't think so.
Thank you.
I also didn't put any of this in writing either. So it's Frederick Bragdon, and I'm the supervising or one of the two supervising attorneys in the Bennington Public Defender's Office in the Defender General System.
Thank you.
Thank you very much.
And just so we're clear, I'm speaking on myself, not on part of the Defender General System.
Understood.
you.
Thank you. We'll move now to Kelsey Schweitzer.
Hi, can everyone hear me okay?
Yep.
Yes.
Great. My name is Kelsey Schweitzer, and in my 3 years on the bar, I've had the opportunity to bring cases before Judge Walsh and submit motions before Judge Barra. So I want to talk about the retention of both of these judges. I definitely have a favorable opinion of both. I know that I've been grateful for Judge Walsh's experience on the bench in the environmental court. It's invaluable to have a judge with a background and knowledge for this court, which is peculiar as far as the courts go. This is particularly true with the changes that are being actively made to the Act 250 landscape and navigating the political demands in Vermont for more housing while maintaining the rule of law and the deference to towns' individual and unique zoning laws. And Judge Walsh navigates that beautifully and consistently applies the law, I view correctly. Judge Walsh also consistently delivers his merits decisions and rulings very quickly. And that's important in a development landscape because things can really get bogged down with these types of development. Additionally, his demeanor is really excellent. I had one case that settled, and instead of just quickly sweeping it to the side, he took the opportunity to thank my clients and the appellant in that case for working together to reach a settlement agreement, which was very meaningful for my clients. I think this bench demeanor is invaluable in these property cases, which frequently become very heated. And having someone who takes the time to explain the process, produce well-reasoned, thorough decisions, and thank people for their cooperation goes a long way. So I would definitely recommend the retention of Judge Walsh. While I have not had the opportunity to appear in court before Judge Barra, I have submitted several written motions to him in my 3 years at DRM. I've found his decisions to be thorough, well-researched, and written as like a clear explanation to the non-prevailing party rather than to the Supreme Court. Like, I feel like a lot of decisions are written as like a justification to the Supreme Court and not to the parties themselves. In his time on the bench, he has become one of the favorite civil judges of many of the DRM attorneys, including some tough graders in our group. And it's his willingness to make tough decisions without punting and his well-researched and well-reasoned decisions that have earned him that reputation at DRM. So I would also recommend his retention.
Great. Thank you so very much.
Yeah.
We'll move on to Chris Roy.
Thank you very much. And I'll ask like everyone else, can you hear me?
Yeah.
Okay, thank you. And I do appreciate the time to come before you and deliver a few very short comments about Judge Walsh. My name's Chris Roy, and I'm chair of the litigation group at Downs Racklin Martin, though I am appearing in my individual capacity. Judge Walsh and I go back to more than 20 years now. I served on the former Vermont Environmental Board back in the mid-2000s, and Judge Walsh was the enforcement attorney for the board. And so we've known each other professionally over the course of a quarter century or so. And I have always found him to be very good at what he does, be it when he was an enforcement attorney, when he was in private practice, or as a presiding judge before, or in the environmental division. I'm not going to say I win every time I'm in front of Judge Walsh, and frankly, I don't know if it would be a good system if I won every time, as much as my clients would probably like that. What I always tell my clients about Judge Walsh going into a hearing is that he'll be well prepared, he'll understand the subject matter, he'll treat both sides with respect, he'll be clear from the bench, and he'll issue a clear decision in a timely manner. And as I tell my clients, at the end of the day, you can't get any guarantees in this process, but if you have all that coming from the judge, that's about as much as you can ask for. Judge Walsh also has the very tricky task in the environmental division of dealing with a lot of pro se litigants in a lot of very emotional situations. Former environmental judge Meredith Wright used to call the environmental court family court for neighbors. And there is a certain amount of truth to that, because people clearly, if you have projects in their neighborhood that they feel strongly about, it's very personal. A lot of people do appear in front of the environmental division without the benefit of attorneys. And Judge Walsh has to balance the need to follow the rules, move things along in a timely manner, but also give these pro se litigants an opportunity to present their views, to help guide them as appropriate through the process, to ensure that at the end of the day, the process has been a fair and comprehensive one. And I cannot think of a case I've been practicing in front of Judge Walsh since he was elevated to the bench, and I can't think of a single case, win or lose, when he has not comported himself in that way. So I would certainly recommend that you folks vote to retain Judge Walsh. And to the extent you may have received comments along the way from folks who may not have had an outcome that they like before Judge Walsh, please temper that with, again, the emotional context within which many of these matters come. As I said, I certainly do not win all the time in front of Judge Walsh, but I always feel as if my clients and I have been dealt with appropriately whenever I appear in this court. Thank you for your time.
Thank you, Mr. Roy, for your time. And speaking of time,
I have one additional person.
is there anyone else online who wishes to testify?
Hi, can you hear me okay?
You
Yeah.
can.
Okay, yes, I would also like to testify. For the record, my name is Zach Handelman. I'm an attorney at SPF Attorneys in Burlington, and I'm here to testify in support of Judge Walsh's retention. And I just have some written comments that I'd like to read that are on my own behalf and not the firm's.
Go for
My
it.
firm. So my firm represents municipalities across the state, and we regularly practice before the Environmental Division of the Vermont Superior Court. And then prior to joining SPF, I was a law clerk in the Environmental Division for 2 years, where I worked with the late Judge Durkin, the newly appointed Judge McLean, as well as Judge Walsh. My first experience with Judge Walsh was not as his law clerk, but as an intern with Vermont Legal Aid. We were representing a person in emergency motel housing against a town which claimed that the motel was in violation of its zoning bylaws. We were in the middle of a deposition when the parties reached an impasse. We decided to call the court for an impromptu conference, and we were not expecting the court to accommodate this last-minute request. The judicial assistant picked up the phone, and within a couple minutes, Judge Walsh was in his robes in the courtroom, ready to go. He heard from both parties, issued a ruling from the bench explaining his reasoning, and encouraged the parties to work through any remaining differences. He closed by saying that the court was available to resolve any other issues that arose. The deposition proceeded without any further incidents. I think this experience demonstrated how Judge Walsh operates his courtroom. He makes himself available at the convenience of the parties. He He gives every party a full and fair opportunity to be heard and present their arguments. His decisions are clear, direct, and unambiguous, which helps each case move forward without delay. He has high expectations for the parties appearing before him, particularly when they're represented by experienced attorneys. These high expectations have contributed to an efficient, predictable, and respected practice before the Environmental Division. As his law clerk, I have only good things to say about working with Judge Walsh. During my first week on the job, he checked in on me every day to make sure I had everything I needed. He explained that the work would be challenging at first, but that his door was always open. He reassured me that over time I would learn to master the material and that I would hopefully stay in practice in Vermont after my clerkship, which I have. His words were comforting and made me feel like I would be well supported in my new role. As a law clerk, the majority of your role is research and assisting with drafting decisions. You also attend conferences, trials, site visits, and you work very closely with the judge you're assigned to. I always look forward to working on cases with Judge Walsh because I knew I'd play an active role in the case and learn valuable tips about the practice of law. During breaks and trials, Judge Walsh would ask me if I understood what was going on. He pointed out what he thought the attorneys did well, what he thought was poor advocacy, and he never prejudged a case and would keep an open mind over the course of the proceedings. Occasionally, we would disagree on the appropriate outcome for a decision, and I was able to change his mind on a couple of occasions. This showed me that he cares more about the decision being right than himself being right. And as his record on appeal reflects, his decisions are affirmed more often than not. So to conclude, Judge Walsh is an asset to the Vermont judiciary and the state of Vermont, and I highly recommend that he be retained for another term. Thank you.
Thank you so much for being here. Is there anyone else?
We had one other person that I just sent the link to and I asked them to join now.
Okay.
They'd be joining us shortly.
Great.
We have this witness's testimony, the one that just. There was only one person that submitted written testimony and that was the first person.
That's, since you just read yours, can you submit it so we can have it for the record?
Sure.
Thank you. Yeah, and just to repeat, that goes for anyone who would be able / willing to submit your statement
In writing.
yes, in writing. I was just gonna make sure they know how to do that.
Maybe 15 minutes. On those, just now.
And said that he'd be available in 15 minutes?
I asked him to join now, to which he replied, I need 15 minutes.
Okay, well, I think that typically we stay in our open session for at least an hour. It's publicized at 2 hours, okay, until 8.
Fine.
So we can wait for the next witness.
Would you like to pause live?
Sorry.
Would you like to pause the live feed?
Unless you want to watch us cooking.
Wait.
Can you? Yeah, I don't know that there's probably not a requirement that we stay live, right? We're not gonna do anything while we're off live, just for the record. Step eat quickly. So sure, we can pause the live feed. We will be back in roughly 15 minutes if anyone's interested in rejoining. Yeah, they'll get back up and